Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hi, and welcome to Triage. My name is Rebecca Schaefer, and I'm a partner in the firm's healthcare practice group. I am joined today by my colleagues Gina Bertolini and Desiree Moore, whom I'll introduce in just a minute. We are here today to talk about a policy statement issued by the FTC, the Federal Trade Commission, on September 15th, just a few weeks ago, related to data breaches by health apps and other connected devices. The FTC said it was issuing the policy statement to offer guidance on the scope of the FTC's health breach notification rule in recognition of the proliferation of apps and connected devices that capture consumer-sensitive health data. As mentioned, I'm joined by my colleagues, Gina and Desiree. Welcome, ladies.
Thank you.
Thank you so much.
Gina is a healthcare regulatory and transactional attorney who, among other things, specializes in healthcare data privacy and security and assisting providers with HIPAA compliance, breach investigations, and managing cybersecurity risks. Gina also advises on ONC's information blocking rule and has represented healthcare providers, IT platforms, and web-based content developers on structuring telemedicine solutions, as well as the regulatory aspects of developing personal health records, mobile apps, and other health IT products. Welcome, Gina. So glad you could be here today. Desiree Moore is a litigator by background and the co-founder and lead of the firm's digital crisis planning and response client solution. In that capacity, she handles all manner of crises for clients with a particular focus on data security incidents, breaches, and related government enforcement actions surrounding the proper use and handling of sensitive personal information. Again, welcome, and we're so glad you could both be here today. So let's start with the proposition that the FTC's health breach notification rule applies to vendors of personal health records. Gina, can you help us understand the difference between personal health records and electronic health records?
Sure, Rebecca. Yeah, I'd love to. So the electronic health record is what most people think of as their medical record. So when they go to a healthcare provider and they receive medical treatment or care or drugs are prescribed, there's a medical record that is created as a result of that treatment or that visit, and that medical record is part of the healthcare provider's records. Of course, patients have access to their electronic medical records and their paper medical records for that matter, although more and more today we've moved almost exclusively to electronic health records. But in either format, patients have access to those records through HIPAA's individual right to access their protected health information. The difference between an EHR and a PHR is the personal health record will consolidate records from multiple sources. And those sources they would include medical records like we just discussed, which of course includes protected health information, but they might include data and information from other sources as well. So information from, for example, mobile apps. A lot of people have fitness trackers that they wear, wearable devices. Some people who are chronically ill have, infusion pumps, for example, type 1 diabetics, or other kinds of, continuous glucose monitoring devices that they use regularly. And all of those devices, track data. So the personal health record consolidates not only an individual's electronic health records from their healthcare providers, but it has the capability of also connecting or adding to that record all of that data and information from wearables and from things that aren't otherwise covered by HIPAA. And that's the most important piece when we think about a personal health record, is because it is created at the request of an individual who instructs a healthcare provider to take all their records and transfer or download them into this personal health record app, as well as information that comes from wearable devices, it isn't covered by HIPAA. And this is why, in part, the FTC has issued this statement, to make clear that these types of records, which contain sensitive information, are covered under the FTC's health breach notification rule.
Really helpful, Gina. Thanks for that delineation. And so with that clarity, Desiree, can you chime in with a primer on what is the nature of the requirements or the substance of the FTC health breach notification rule?
Sure, of course. And I think it's a really nice segue from what Gina so helpfully described. So to orient our listeners a bit, the FTC's health breach notification rule was originally adopted, I think over 10 years ago now, and applies to vendors of personal health records, as well as PHR-related entities and third-party service providers that either house or maintain certain information concerning U.S. citizens. As Gino is alluding to, it does not apply to HIPAA-covered entities or business associates. And I think that's an important distinction for our purposes today and for purposes of this discussion. Under the rule requires that any vendor who falls under the Act must notify both impacted individuals and the FTC of a breach that implicates PHR. The rule is detailed. It also articulates the timing, placement, and content of the notice. But I think the key takeaway here is that the FTC must be notified of a breach of this nature. And of course, that is a distinction from a breach that does not implicate PHR, where the FTC would not need to be proactively notified. So this is a key takeaway from the rule. The other thing that I think is important to mention, it kind of ties in the policy statement that we're addressing today. The policy statement made a clarification, or at least emphasized an additional component, which is that the rule, for one, applies to any business that collects or maintains PHR. But the clarifying element is the articulation that website and mobile apps like fitness trackers or blood sugar, heart monitoring apps, the kinds of applications that Gino was describing, and these are just some examples, there are many others, but apps that are capable of drawing from multiple sources are subject to the rule. So in other words, if someone inputs blood sugar levels into an app that is also pulling information from the user's calendar or from a social platform or otherwise, the rule applies.
That's really helpful. Thanks, Desiree. With this policy statement being recently announced, what would you anticipate in terms of whether this is signaling an increase in enforcement action or just in the agency's increased emphasis on good stewardship of sensitive personal health record data? But what would you expect in light of this policy statement being issued?
I think you're exactly right. I mean, the policy statement is important because it signals that the FTC is taking a sort of renewed or re-energized interest. And I think that there will be a heightened focus on compliance going forward. And so where previously we were not necessarily seeing enforcement actions pursuant to the rule, in my view, we're likely to see these actions now where vendors are not complying and potentially putting individuals at risk. So that key takeaway is really the heightened focus and an urging, as you suggested, to ensure that any entity that is subject to the rule is mindful of the rule and is looking at their systems and making sure that they are in compliance.
No, thanks for that, Desiree. So, Gina, back to you, if I may. What are some considerations you would commend to healthcare providers who are, covered entities and certainly familiar with HIPAA compliance requirements, but what would you commend to them as they are being asked to contribute protected health information from their systems into these sorts of apps or personal health records?
Sure, that's a great question. First and foremost, I would just say the world is a changing place, and in particular for healthcare providers. And what I mean by that, as it relates to data, is that, for the last several decades, healthcare providers have had to comply with HIPAA, for better or for worse. But HIPAA is, of course, very protective of individually identifiable information within the healthcare setting, otherwise known as protected health information. And that actually has given healthcare providers some comfort. And in fact, I think healthcare providers have grown very protective of their patients' PHI, protected from, vendors who may want the data for commercial purposes, protected from, disclosures that aren't permissible, disclosures that would, have a nefarious purpose, wanting private information about individuals. So covered entities have, as they're called under HIPAA, have really taken HIPAA's requirements to heart and are very protective of their patients' protected health information. And so it only serves to reason that as these mobile applications and other wearable devices that focus on data and health-related data, as they proliferate, that healthcare providers would be uneasy about disclosing their patients' protected health information and perhaps a little protective over whether their patients understand the privacy risks. So two things I would say there. One, I think this statement by the FTC, which, as Desiree explained, reminds vendors and creators of these applications of the FTC's health breach notification rule is helpful. It can be perhaps give comfort to healthcare providers that there will or may be enforcement mechanisms for these kinds of applications that aren't otherwise governed by HIPAA. One thing I thought was really interesting in the actual statement is that it places entities on notice of their ongoing obligation to come clean about breaches. And I thought that come clean about breaches was really interesting. As covered entities know, they've had an obligation, for years and years to notice the Office for Civil Rights regarding any HIPAA breaches. And it looks to be that the FTC is reminding these non-HIPAA entities that they too have obligations if there are breaches of this sensitive information. So I think it can give our healthcare providers some comfort that there may be an enforcement mechanism. And the last thing I'll say just very quickly that I think healthcare providers need to be mindful of is the information blocking rule, which is the Office for the National Coordinator for Health IT's final rule was issued in 2020. Its purpose is too broad, for the scope of this podcast. But what I will say is that as a component of the information blocking rule, it does require healthcare providers to download information to third-party applications or providers at the request of their patients, and to not interfere impermissibly with those requests or those downloads. They can inform their patients if they think there are significant privacy risks with downloading the patient's information, but they can't prevent it or otherwise interfere. And that's according to the ONC's information blocking rule. So that's another aspect of this that healthcare providers need to be mindful of. And again, I think the FTC's statement is a good reinforcement or a good reminder for healthcare providers that there are other tools available once that information is downloaded.
Yeah, no, that's very helpful and hopefully gives some comfort that, even if no longer subject to HIPAA, there are still other regulatory regimes that will promote good stewardship of that sensitive health information as it continues to reside in the personal health record that the individual directed. That's really helpful. So just mindful of time, I wanted to invite each of you to just sort of offer your closing remarks or practical takeaways for our audience. And Desiree, if I could start with you, maybe focused on perspective of the health app vendors.
Absolutely. On the vendor side, I think this is an excellent reminder that vendors should be thinking proactively about privacy and security and really, refocusing in that area if there has been any, kind of just turning attention elsewhere. And then in the wake of a data security incident or a breach, ensuring that the vendor is compliant with FTC expectations. That's just an absolute that we take away from this rule. And, as it concerns vendors, we want to be sure that, no vendor is made an example of because of not adhering to, the FTC's expectations. The other practical takeaway, and it's in line with this notion of sort of ensuring that there's a focus on privacy and security, simply to think about what you can do proactively. So an incident response plan, for example, in advance of any incident is an excellent way to ensure that if and when a breach arises, a vendor is well positioned to issue their notifications to individuals and to the FTC as may be required, and to think about, all of the other things that arise in the wake of a breach. So doing some proactive things at the outset, taking some proactive measures will go a long way to ensuring that a vendor is well positioned on the back end as they're interfacing with the FTC and with individuals.
Thanks, Desiree. That's really helpful. Appreciate that perspective. And Gina, over to you. If you might offer any, parting remarks or practical takeaways, perhaps focused on the healthcare provider's perspective.
Sure. I think the most important practical takeaway that I can think about is that it's important for healthcare providers' compliance departments to be working in conjunction with the IT departments and with the legal department to make sure that they're understanding the parameters of the requirements for downloading, complying with their patients' requests to download PHI into third-party applications and other tools like mobile applications. So as I mentioned, the information blocking rule, the HIT requirements under the information blocking rule, which is applicable to healthcare providers that have ONC certified health information technology, dictate certain technical standards related to the APIs, the application programming interfaces that healthcare providers need to have available so that patients can safely download their information into third-party sources. So I think it's really important for those departments within the healthcare providers to come together to understand the technical requirements, the compliance side, and the information blocking rules, the requirements that healthcare providers not interfere with these kinds of requests. And then lastly, I would say to coordinate as well with healthcare providers, because what I'm seeing with my clients is that as this culture changes, it can cause some angst and some consternation among those who are interfacing directly with patients who are receiving these requests or asked to, share this information. And I do think it's important for those on the front line, the healthcare providers who are generating the data and reviewing the data and interfacing with patients, to understand that patients have these rights and that these tools can be very useful for patients in taking a more proactive approach to their own healthcare, but also for healthcare providers to have increased access to data from multiple sources, and patients who are willing and interested in not only sharing but also accessing that data.
Certainly. And again, some comfort that even if no longer protected by HIPAA, it's not the Wild West. There are still privacy and security expectations articulated by the FTC and obviously other stakeholders in the regulatory landscape to protect personal health records and this type of sensitive health information. So that's really helpful. I really appreciate both of you making time to be here today and share your considered and informed perspective with our audience. And thank you to our audience for dialing in. We appreciate your time. And of course, let us know if you have any questions. Thanks, everyone.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.